At this time, the court finds it appropriate, I will lift the protective order and grant the defendant's motion for leave to subpoena the two witnesses for well, your motion says for deposition and or live testimony. The court's
Correct.
going to put testimony.
That's what the case management
At
order.
the hearing, not deposition.
The case management order referred to both, Your Honor. I can give it back to you.
But I'm telling you how I'm ruling.
I'm sorry to interrupt, Your Honor. So then the court is finding good cause to lift the protective order, to grant them leave
Based
to.
upon that case management order.
The case management order required them to show good cause here, correct, Your Honor? In order to lift the protective order.
Not the way I read it. I think it was specifically laid out of what they were to do. And
we've done that.
if the bank has objections, they need to be filed.
Yes, sir.
But from that, it appears, I think it's very clear that there is an evidentiary hearing on their motion to disqualify. And the court will allow them to subpoena those two witnesses for the testimony, not for deposition, but for the testimony at that hearing, the evidentiary hearing.
Your Honor, if I may just object, the case management order says that we are to be here
I
for.
understand. I'm making the ruling from what y'all told me today, that there is an evidentiary hearing. Now argue with me.
Sure.
Either side. This is it. It's done. Now, that doesn't preclude the plaintiff for filing objections to the evidentiary hearing. But that's not before me right now.
Okay, Your Honor.
It seems clear from the case management order that there was this process that Judge was set up to get to the evidentiary hearing, because she repeatedly talks about the evidentiary hearing. So it appears that the defendants have properly filed for leave to subpoena those two witnesses. And the court finds that it's not necessary for a deposition, but it's necessary for an evidentiary hearing on their motion to disqualify counsel.
May I ask, Your Honor, how we would prepare for the evidentiary hearing without the opportunity to depose the witnesses beforehand?
Well, the court finds it's not necessary, and you can when the witnesses come, you can call them to testify as to what you just presented. They're either going to testify to what they did.
I understand, and I appreciate, Your Honor, we have some proposed orders here for signature on that point. We're pro
I
se.
have ruled.
Yes, ma'am.
That's it.
Your Honor.
Now, that doesn't mean that the plaintiff cannot object to the evidentiary hearing.
But that does not protect us, Your Honor, in terms of a preparation for I've never had an evidentiary hearing. I've never,
I can't help you.
well, you can by following the case management order, which
I followed it as best I can.
I see.
Okay, so.
Our motion is for both, but her order is for only.
Perfect. Thank you very much, Your Honor.
Of course, and that would be for your motion
With the objections.
with the objection.
Okay. Thank you very much, Judge.
Your Honor, we've got proposed orders for today for you. Counsel is approved. One order for each witness. And will the court file the motion for commission with respect to Mr. or should we file that with the clerk?
I've already given it to the case.
Thank you.
The next one is, the September one is 15 minutes.
I don't know, how long is the
Should be 15
September?
minutes.
How long is the September hearing?
15.
15 minutes.
And it's not,
It's not set
It's not that, it's not the hearing on your motion.
Of course.
It will be the hearing.
On his
by
objections.
separate opinion.
Okay.
Fantastic. Would it be okay for Your Honor if we were to also notice an objection to the order? We do believe we have the right to depose those witnesses beforehand. We'd like to discuss that during the same period of time.
Yeah, you can file that.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
May we be excused, Your Honor?
Sure.
Thank you.